This is News at Prime. Let's bring you this story now. 5 men accused of murdering rapper Kiernan, a.k.a. Forbes, and celebrity chef Tebello Tibz Motsoane will return to court next week, Wednesday. This is for the continuation of their bail hearing. Today, accused number 4, Motsoane, made his case for bail. He alleges that, or he is alleged, I should say, to have orchestrated the murders which took place on Durban's Popular Road. This is Florida, last year, February.
The 803,000 rand was paid to me from a reputable company who I have done business with before. In fact, our business relationship goes back as early as 3 years back. Given the above, I record that the investigations shall reveal that this was not a once-off payment as alleged. The basis upon which the state bases its case is premised on a self-created conspiracy theory regarding the sequence of events that led to the killing of the deceased.
All right, let's speak about this now with the Justice Minister, Ronald Lamola, who joins me in studio this evening. Minister, good evening to you, and thank you for your time. So, extradition papers have now been filed by South Africa to Eswatini for the 2 accused to be brought back to South Africa. Do you feel, as a department, that you have moved with the necessary speed here?
Yeah, thank you, Goli, and to the viewers at home. The papers have been filed in terms of the extradition agreement between South Africa and Swaziland, and in terms of the extradition protocol. And in terms of the extradition treaty and agreement we have with Swaziland is that if someone is arrested in South Africa or in Eswatini, the extradition papers must be submitted to the requested state within 30 days of the arrest. So the extradition request has been filed within the 30 days as stipulated by the extradition treaty. And you'll be aware that before you filed the papers, and the reason why you have such a clause in the extradition agreement is to enable the 2 authorities to exchange notes when someone has been arrested. Because when there's a warrant of arrest, you don't know where the person will be arrested, in which country. He can be arrested in Zambia, he can be arrested in Namibia, and so forth. So you will need to exchange notes before you file to ensure that the papers are in order. And we can confirm that the papers that were filed are in line with the extradition treaty and the agreement with the Eswatini.
I can make reference to a number of extradition attempts by South Africa to get people of interest who are in other countries now but who are alleged to have committed crimes here, and it has been a struggle. So I'm going to go straight to whether or not you are confident that what you have said to the authorities in Eswatini is not going to stand in the way of these 2 being brought back to South Africa, but also importantly, they have raised safety concerns. Can you assure that whilst they are in the South African judicial process, they will be safe?
Yeah, firstly, extradition can be a protracted legal process. It's like that across the globe. Countries engage in an extradition process, even most of the developed countries like the US, London, and so forth. So it does happen. Even in our country, I can tell you now, there are a lot of extradition matters in front of our courts where the people that are being requested by the requesting country are filing all points of procedure and so forth to delay the extradition process. I can confirm that we are confident that the papers we have submitted in Eswatini are in line with the extradition treaty and the extradition agreement, and that in our facilities, we house more than 155,000 plus minus inmates, and they are one of the safest facilities in the world. We house them, and we do indeed provide all programs related to rehabilitation. But that cannot stand as a ground to say they won't be safe in our facilities. We house a lot of inmates, and we've got a good track record. There is also an independent inspectorate for our correctional facilities. When there are challenges and problems, they go through that process.
Yeah, well, I'm not going to belabor the point. However, we have heard incidents of prisoners being attacked, and Nandi Pamakudumana is one such example. But I want to...
Yeah, but if such things happen, there must be an investigation, there must be processes that relate to that matter.
All right. The important point here, Minister, is that you have a case that's before courts, and it's one of the most serious crimes we have seen in this country, where the preferred way by criminals to kill people nowadays is assassinations, contract killings. The Minister of Police, I think he's on record as having said he is confident that the right people are before court, and these are people who are alleged to have executed on this crime. Is that the same way you feel? Is that the kind of confidence that you can instill to the Forbes family tonight?
Yeah, obviously, from our perspective, as a central authority dealing with the extradition matter, the NPA has presented what they believe it's a case that the two accused have to answer in our country. And on that basis, we believe it complies with the extradition treaty that we have with Swaziland and the SA-SADC protocol. And it is on the strength of that facts that we have submitted the application to the Swaziland authorities that the two accused have got a case to answer in our country. And it will be for the NPA to attempt to prove the case beyond reasonable doubt in our courts, and also for the courts to assess the evidence.
Can I move on to a different topic now? And it's got to do with the conduct of judges. There are more and more cases of judges sitting before disciplinary hearings, whether it is for non-performance or indeed the conduct, personal conduct. Are you worried that the more we see these cases, the more it is that public confidence is going to start chipping away, if not already, in the judiciary?
Yeah, obviously we are concerned about such incidences, and also the fact that there is a growing list. But we appreciate the fact that due process is taking place to hold the judges accountable in terms of their code of conduct, and to restore the dignity of the court, and also to restore public confidence. Whilst that process has been taken through and it's run in public, everyone can see that the judge, there's no one who's above the law. They are accountable. The process takes its own life. I think it's a process that has been established by our own constitutional democracy. It should be allowed to take a life of its own.
These are people, Minister, who dispense justice, and they see themselves, or should I say, they find themselves on the wrong side of the very law they are supposed to uphold. And we speak here tonight with two of these judges who have since been impeached in a democratic South Africa. That's a first. Again, I ask you this question. Is there worry on your part as to the conduct of judicial officers and what is being done about it?
Yeah, so is that not the reason why there must be a process? And I've already said that indeed we are concerned that such a thing is happening. But we find resonance on the fact that they are taken through a process. And that process does not have eyes, whether they are judges or not. They've been taken through, and Parliament has also expressed itself on, with regards to the two judges that you have spoken about. The other ones that are going through, they have been taken through a process that is public. The public can see for themselves, to ensure that those who dispense the law are as clean and are as beyond reproach as it is expected. So the process of accountability does restore the faith and the confidence of the public on the system.
I'll tell you which process starts creating doubt in the confidence of the judiciary. It is people whom you sit with in Parliament across the benches. It's politicians who slowly chip away at that by saying that the judiciary in this country is no longer independent, and therefore they will point to such cases and why it is that the people of South Africa should start questioning the judiciary even more. And so how do you instill that message to people like yourself?
You know, the reason why the impeachment process is so well guarded and it has got checks and balances is there is lots of steps. The Judicial Conduct Authority, the Judicial Service Commission, making a recommendation to Parliament, and it's because it's to protect the independence of the judges. It's to make it so difficult and not so easy to impeach a judge. Once the judge is impeached, you know that all due processes have been followed, and that process was followed in the full glare of the public. So that is a safeguard of the judicial independence. So that argument will never hold water, because the judges have been taken through a process. It's not like me, where the SG of the ANC or the president can wake up tomorrow, call a press conference that the Minister of Justice is now Xoli Mngambe. There's a process. With me, it's just happened with the press, with a click of a button, I'm gone. But such a thing does not happen with judges. There's due process.
So, final question on the conduct of judicial officers. With these two judges that have now been impeached, I saw a story recently that the now impeached Judge John Hlophe, no longer, he should not be referred to as judge, by the way, he is understood to be taking the process to court, and this is over his financial benefits. Where do things stand in that regard? Is there some leeway for him to be able to access that? Because if that is the case, you will surely see Judge Nkola Motata possibly following the same route.
Yeah, no, I've not yet seen the application for review, so I will not really be in a position to comment. We will deal with it whilst it comes. But as you are aware, what guides us as a department is the remuneration of judges and also the Constitution. The Constitution is very clear with what happens on impeachment. As you are aware, judges are paid for life. But on impeachment, that kind of benefit is forfeited. So that is what is there, is in the Constitution. But if there is any application to challenge that particular aspect, we will deal with it as and when it arises.
Let's talk corruption. And without asking you about the process that unfolded today at the private home of the Speaker, because my understanding is that that will trip you up in terms of the separation of powers. How do you instill confidence in South Africans that the cases that are before court are not going to fall off, Minister? And I'm saying this on the back of a few that have fallen off already.
Yeah, obviously that the response in terms of the facts and the evidence is better placed with the NPA. What we do ourselves is to provide them with the resources, with the necessary laws that enables them to do the job. The NPA Act, the Criminal Procedure Act, and also the resources that the NPA needs to do their job. But in terms of to decide whether to investigate, whether to prosecute, it's a decision that they must take on the basis of the strength of evidence in front of them and what the law says. So we expect that they must ensure that once they take a matter to court processes and all that, they themselves have assessed it, they are convinced that they will be able to prove it beyond any reasonable doubt. So we do hold them accountable in terms of what is expected, because society does expect visible outcomes of the NPA dealing with crime, dealing with corruption, dealing with that and that. and so forth. So that is what we expect, but we can't really say on this case, this is what you need to do. This is not my job. My job is to ensure that whatever that they do is in line with the NPA Act, is in line with the Constitution, and is in line with the laws of the country.
Are you satisfied with the performance of the NPA and indeed the unit that is under it, the investigative directorate, the very people that raided the home of the speaker today? Are you satisfied with how they've been handling these cases? Because, as I say, there are two major ones that have already fallen off the court roll.
Yeah, as you are aware, they themselves have raised the fact that some of them, that as you said, they've fallen off in some of the courts. They are looking at whether they should appeal or not appeal, and they are also looking in their own internal mechanisms to review. We obviously have to say we are still satisfied with the work that they are doing, because if you look at the history of the NPA, they have not really had a lot of cases that they were prosecuting on corruption. So these are cases where there is a lot of complex matters, there is a lot of challenges, and with time and with practice, I believe that they will be able to take matters in a manner that they can be able to prove beyond reasonable doubt, and it's a manner that will be responsive to the laws of the country. It will take some time, but I think with the matters that they are taking to court, they are gradually getting there, and I think with your interviews with them, they've been able to account even in Parliament.
Well, I can tell you for certain that they have not been to this show for some time, and we have extended invites. They simply will not come through. Instead, their preferred way of communication is via WhatsApp these days and sending voice notes. That is not satisfactory, Minister. Before we take a break, if you are genuinely satisfied with their performance, why has the Steinhoff case not gotten off the road? The Germans are moving.
Yeah, we have. I have also raised a concern on the matter of Steinhoff, and they have assured me that there is investigation that is ongoing. There is a process that will lead to a decision to prosecute or not to prosecute on the matter. It is a matter of national interest to the people of South Africa, so they need to account, and I know that from time to time they do update a society. It is a matter that we also from time to time expect that they must account to the people of South Africa where they are and what is happening with the matter.
Let's take a break, because when we return, I'd like to ask you about whether or not you're genuinely interested in upholding the law, or you have been as the 6th administration. And I'll tell you exactly why I'm phrasing this in that way. Let's take a break. When we return, we continue the conversation. You're watching News at Prime. If you're just joining us, we are at the tail end of a conversation with the Minister of Justice and Constitutional Development, including Correctional Services, Ronald Lamola. Minister, before we took to a break, I said that there is something to be said about whether or not the government of the day is committed to following the letter of the law on any matter, particularly when it comes to criminal justice system matters. When you sit here today and you watch or you look back at cases like that of Shabir Sheikh, who was said to be dying, former President Jacob Zuma was let out on medical parole. The courts said no, and you decided that you were going to let him out on special remission. It's one thing for prosecutors, the police, to do their jobs, but it's quite another when the administration of the day will do its best to subvert that. When you sit here today, just on these two cases, Shabir Sheikh and former President Jacob Zuma. Can you convince the South African public that you acted in the interest of justice?
Yes, we can, Goli. The Shabir Sheikh one, I don't know, I was not there. The one I can say that we acted in the interest of justice is in relations to the special remission. We, as even today, have high level of overcrowding, and we explained the decision at the time that we had to take action to release offenders, low-risk offenders, to reduce the level of overcrowding. And it's something we do from time to time, as and when a need arises. And the need at that time was expedited by the challenges we had at the burning of a prison in Kutamas in Tumul, where at one night we lost about 3,000 bed space at a go. So we did not have space. We needed space to further rationalize and distribute the inmates across the country. And it has really helped us. We are at this stage in the process of recommissioning back Kutamas and Tumule, where we will now take back inmates into Kutamas and Tumule, because that bed space, we still need it today because the numbers are still increasing. So we will be taking them back now as soon as it has been handed over back to the processes that the correctional service is undertaking.
So it is your argument that there is no law for ordinary South Africans like me who have no money, nor am I a politician, versus someone who is either a politician or has lots of money and simply cannot stay in jail. Do you know why I'm phrasing it like that?
No, I don't know.
There is an inmate who died in prison. He had brain cancer. It relates to the matter that took place in Cape Town of the murder of a British national. He died in prison, was never let out on medical parole. So I'm going to ask you again. South Africans sitting and listening to you today, can you convince them that there's a law for them, or rather there is no law for them, versus a law for a politician or a business person with deep pockets?
Unfortunately, the case you are referring to, I don't know. But from time to time, I do sign a medical parole that relates to lifers. Today was one of those days where I also signed some of the medical parole related to lifers, and also some of the parole related to lifers. So seated here, I can confirm that there is no law for ordinary citizens and law for politicians or for business people. The law in our country is the same. Everyone must be treated equally before the law. And on a day-to-day basis, there is a lot of inmates that are released on parole every day. And some of them are not even politicians. They are just ordinary inmates. It happens every day. And on my desk, from time to time, I do sign for lifers. And some of them are not even politicians. So the law is for everyone. It's equal in our country.
On the occasion of a conference on human rights, in a year that we are going to be commemorating 30 years of democracy, when it comes to the South African judicial system functioning so that all of us are seen as equal before the law, what is it that you can use as an example to say, this is why we fought so hard for this constitution, which is celebrated the world over, and in particular my domain, the criminal justice system, it has treated everyone equally, even with the examples I've put to you?
I've already given you examples. The Chief Justice, when he spoke at the conference, he says there's never been a day where he was called by anyone, even ministers or the president, to instruct him what to do or what not to do with the matter. We have been very clear, even for the NPA, we do not interfere with their work and nor with their exercise of prosecutorial independence. The system is functioning as per what the Constitution prescribes it to do. Our task, and that is the reason why we convened the conference, is to take stock of the last 30 years with regards to the entirety of the Bill of Rights, including the socio-economic rights. And the conference, from the assessment of the conference, is becoming very clear that we have not yet achieved an equal society in terms of economic rights. So that is the revolution that we need to conclude.
Finally, Minister, we are in an election year. Can you guarantee that swift action as part of the minister that is within the criminal justice fold, can you guarantee that swift action will be taken against those who attempt to disrupt these elections, whether it be through their comments in the public space or incitement or even violence?
Yes, action must definitely be taken to whoever incite violence, who wants to disrupt the elections. The elections must be free and fair. It must be run in terms of the Electoral Act and the Constitution of our country, where South Africans are allowed to exercise rights freely and without any type of threat of violence. So, indeed, it is something that has to be done in line with the Constitution. And if anyone act outside that, action must be taken.
Swift action must be taken.
Now, action must be taken.
I think the interest is swift action because, Minister, we cannot afford 30 years into democracy, a period where there is volatility before an election. That is something that our parents have seen pre-1994. It cannot be that 30 years into a democracy, people are subjected to that kind of behavior. So I guess I'm looking for stern action or perhaps stern words from you.
Yeah, swift action must be taken only on any matter that might disrupt the peaceful running of elections, either through incitement of violence or through whatever that may destabilize the running of the elections. And I believe that the law enforcement authorities, they've got the prescripts. The law is very clear what they need to do. They should do it. And unfortunately, myself can't instruct them to say, go and arrest this one, go and arrest that one. They know what the law says. And also the members of the public and society as a whole have got a responsibility as and when such things happen to report it and also to follow all the processes that are outlined by the IEC and also our own laws in the country.
Thank you very much for your time. Ronald Lamola, Minister of Justice and Correctional Services. I do thanks indeed.